Hi everyone, this is Attorney Lilian Chukura with Lily Legal, where we help our clients get green cards and citizenship for themselves and their families using the U.S. immigration law system. So, today we are going to jump in because I know this question is something that I get asked all the time. Should you file a fiance visa or a marriage based visa? Right? When you are going through the process and you're trying to decide which way to go, let's talk about it. Ask me questions in the comments. I'm going to go through the pros and cons, what the requirements are for each type of visa, and then you can decide whether that is something, whether the fiance one is something that you want to do, or if the marriage one is better option for you. Okay. I am Deepak on Instagram. So if you are watching this, feel free to go ahead, like, share, and subscribe. And as always, if you would like to schedule a private consultation with me, you can always do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. So let's jump right in. What are the requirements for a fiance visa? One, you have to have seen your fiance in person within the past 2 years. Okay, you must have seen your fiance in person within the past 2 years in order to qualify for a fiance visa. You also have to be a U.S. citizen. So if you are not yet a US citizen, the fiance visa is not an option to you. So keep that in mind. If you are not a US citizen, the fiance visa is not an option in your particular situation. So let's start there. Sorry, it's not. So the marriage visa would be the option if you are a permanent resident and you have a fiance. You would need to get married and then file for the fiance for based on a marriage visa. Okay, not a fiance one, unless you're going to wait until you become a citizen in order to file for your fiance. Okay, so fi- fiance visa must be a U.S. citizen and must have seen the fiance within the past 2 years. The marriage based one, you can file it as a citizen or a permanent resident. And you do not have to have seen your wife within the past 2 years. So let me explain that. Let's say you were married in a different country, and then you got the opportunity to come to the US, let's say through the lottery visa or another type of visa. Now you are here, you have your green card, and you want to file for your spouse. Well, you don't have to have seen the person within the past 2 years. So let's say you got married in 2015, but you haven't been able to go back to see your wife since then, but now you're ready to file for her. Well, you still can because there's no requirement that you have seen her within the past 2 years. That is solely for the fiance visa um, process. So marriage based, if you haven't seen the person within 2 years, it doesn't matter as long as you are legally married and your marriage is recognized. Okay, so those are really important, and I'm going to touch on that. So that's the first thing with the marriage based visas. US citizen, permanent resident can file for it. You don't have to see each other within the past 2 years. That's not a requirement, right? Now, for the marriage one, you do have to show that your marriage is legal. What does that mean? It means that it, if you did a proxy marriage, right, a marriage by proxy where you were not physically there when the marriage took place, you have to show that you have, right, that you have consummated the marriage in order for the proxy marriage to be valid, right? There are certain states that do not allow for proxy marriages in the US. So if you live in that state, keep that in mind because if it's not allowed in your state, you can't do it. So another example of valid marriages is if you there's some countries that allow first cousin marriages. Well, in most states in the US, it's not allowed. So then the marriage will not be recognized in those states. However, if you live in a state where that type of marriage is recognized, it does not matter that other states do not recognize it. As long as the country where the marriage took place recognizes that type of marriage, and the state that you live in recognizes that type of marriage, then you can still go ahead and file the marriage visa application for your spouse. So it is so important to know that while going through the marriage visa process. So while going through the marriage visa process, you need to make sure that your marriage is valid. That's the bottom line, right? If the marriage is not valid, you're not actually married for immigration purposes. Another thing you need to keep in mind with a marriage-based visa is if either you or your spouse has ever been married before. So this actually applies to fiancé visas as well, because you have to show that you are free to get married with a fiancé visa, and then you have to show that when you got married to your spouse for the marriage visa, that you were free to get married. Okay, so either way, you have to show that if you were previously married, or your spouse was previously married, you have to show that that previous marriage was terminated, and you have to have documentation of that. Okay, so that's where the two applications kind of go hand in hand, is that you still have to show that your marriages, prior marriages ended and ended legally. Okay, so what does that mean? It means that whatever country that the marriage took place in, that it took place based on their laws, right? So if you are in the US, I'll give you a quick example. If you are in the US, and for example, in Massachusetts, in order for a foreign divorce to be recognized, so a divorce that took place in either another state or another country to be recognized in Massachusetts, either you or your ex spouse have to have lived in that state or country at the time the divorce took place. So, not that you lived there at some point in the past, but that was your residence. So, if neither you nor your spouse lived in that foreign country or state, it will not be recognized, because guess what? Neither of you were residents of that state or country. Okay, so you really want to make sure prior marriages ended properly and your marriage entered into properly, right? So now the next difference is the financials, right? Because at the end of the day, sometimes it really comes down to the financials. How much is it going to cost to do the fiancé visa versus how much is it going to cost to just do the marriage visa, right? Um, I'm, I go through this all the time with people. So I know that the financial part of it does make a difference. So I'm not going to gloss over that. We're going to talk about it. So, with a fiancé visa, for example, you are going to be doing it in three parts. So, you're going to be paying fees at three different stages of the process. So, the first stage, the I 129F, that fee is $535 for the fiancé visa. Once that is approved and sent to the embassy, you do the DS 260, the DS 160. Sorry, y'all. So you do the DS 160, you pay the fee for that. Typically, it's around 260. Okay, $260 to be specific. And then when the fiance gets the visa, comes to the US, you get married within 90 days, and now you're ready to apply for adjustment of status. That fee is $1,225 that you will have to pay in order to get to apply for the green card in the US. So those are the fees associated with the fiancé visa. For the marriage-based visa, again, these we're talking about your spouse is outside of the US, not your spouse is within the US. Okay. Your spouse is outside of the US and you're filing for them. The fees involved, filing fee wise, is $535 for the I-130 that's done in the US. Then once it gets to the National Visa Center, you're paying an additional $445. At that stage, your spouse gets the visa, and then you do the green card fee to USCIS, which is $220. Okay, so if you calculate it, the fee for the marriage base is cheaper than the fee for the fiance visa. So that's just on a financial only consideration. Like if that is your only consideration, it's how it's going to cost. That's the breakdown of the filing fees. Okay. Now, keep in mind that there are fees for medical exams, which is required for the fiance visa and the marriage-based visa. Okay. And if you're getting married, you're most, depending on if you're just going to do a quick court marriage or if you're actually going to do a full-on wedding, there's fees involved with those as well. So for you, depending on your particular situation, even though filing fees wise, the marriage one may be less expensive, but in reality, if you're doing a full wedding, that may cost more on the front end than when they get to the US and you do all of that. So keep all of that in mind. So that is the financial aspect. That's the difference between the fiance visa and the marriage based visa. Of course, if you're working with a lawyer, they will have their fees for those. So while you're talking to a lawyer about your options, that will be something you would discuss at that end. Okay. Now, the next financial consideration is the affidavit of support. So basically, anytime you're filing an immigrant visa, so any visa that would lead to a green card, let me put it that way. The visas that will lead to a green card. So the fiance visa, even though it's technically a non-immigrant visa, if you go to most embassy websites, they will have it under the immigrant visa section because it's a visa that will lead to a green card if you follow all the steps and do all the things you're supposed to do, right? It's a visa that will lead to a green card. So it needs to meet certain requirements. One of those being the affidavit of support. Basically, the petitioner, for fiancé visa purposes, the U.S. citizen. For marriage purposes, it could be a U.S. citizen or a lawful permanent resident, right? The petitioner has to show that they have the financial ability to support the person that they are filing for. Okay. The petitioner has to show that they have the financial ability to support the person that they are filing for. So, financial ability depends on your household size. If it's just you, an individual, and you are filing for one person, your income typically, if it's around at least 25,000 a year, you should be just fine. Of course, there is a whole chart that tells you based on your household size how much income you need for an affidavit of support. It's on the USCIS website, so you can get into more detail depending on your household size. Okay. Now, for the marriage-based case, you have to fill out an I-864. For the fiancé visa, you have to fill out an I-345. Sorry, y'all. I just went blank. But the difference in these two things is the marriage-based one is more stringent, right? It has a higher requirement than the marriage, than the fiance one, because technically for the fiance one, You only have to show that you have employment and you have income coming in. With the marriage-based one, the I-864, you have to show, your income for the past 3 years. You're currently employed. You are meeting the household size income requirements. It's just it requires more of you. To show that you can actually support this person. So it's really, really important that if your income is not up there and you're trying to sponsor someone, that you are really paying attention to what the requirements are. You do have the option of having a joint sponsor. So basically, someone else's, if you have a family member, a friend that's willing to put their income and say that they're willing to support the person, your fiance in this situation, you can do that as well. So again, there is a heightened level of income required for the marriage-based case versus the fiancé visa. Because at the end of the day, with the fiancé visa, when your spouse comes in and is applying for the green card, you still have to do the I-864, which is that heightened affidavit of support. So they let you get away with a lower requirement um, on the front end, knowing fully well that when it's time to apply for the green card, that you will need to meet the heightened requirements. Okay, so don't think that just because you file for the fiance visa that you're getting out of the heightened requirement. No, you're just going to do it once your fiance gets to the US. Okay. So those are the financial considerations as far as the fees involved and the affidavit of support. You want to really think about those two things to make sure that one, you're able to meet the requirements, or at least you start having conversations with people that can be a co-sponsor or a joint sponsor for you. Okay. Now, as far as the process, right? With a marriage-based visa, when your spouse comes into the US, they are a permanent resident of the US. With a fiancé visa, when they come into the US, they have a fiancé visa. They are not a permanent resident of the United States until you two get married and file the green card application, have the green card application approved, and then they are a permanent resident of the US. So it has more steps that you have to do after the fiance gets into the US than the marriage based one. Because for the marriage based one, once the visa is approved and they come into the US, they are a permanent resident. The only thing they're going to be waiting for is just their physical card. Okay, that's really it. They're only waiting for their physical card, not um, anything else. But with the fiance one, there is extra steps. So after you wait for the fiance visa to be approved, go through the interview, do all of that, you still, once they come into the US, you still have to apply for a green card, and you may still have to do another interview in the US. So it's really important to keep that in mind as you're trying to figure out which process you want to do. Historically, as far as timing, the fiancé visa did have a shorter time frame. However, today, right, post COVID, post COVID shutdowns and all of that, the timing for the fiance visas and the marriage based ones are kind of, right there. The fiance one may be like a smidge faster, but it's not what it used to be, right? Before the I-129 F can be approved within 6 months, right? It's approved and you're moving on to the visa stage. Right now, the processing time is about a year. And in some places, it's longer than a year. So the processing time for just the initial application with USCIS is about a year. And then after that, you have to apply for the visa. Some embassies are so backed up that they are not scheduling visa interviews till 2025 right now. So again, the time frame may not be favorable depending on where, right? What embassy your fiance is at. So that's really the important thing. It's not really so let's say, for example, your fiance is in France, you're probably going to have a better outcome than someone that their fiance is, let's say, in Ghana. W- Because, of course, Ghana has a very, very hefty backlog, and their visa applications are going into 2025 at this point. So, would it make a difference in timing between the fiance and the marriage one? Probably not. But again, it's things to consider and talk to your attorney about when you're making the decision, whether to go with the fiance visa or the marriage one. Okay. So if you have any questions, feel free to reach out or put them in the comments. I do go back and respond to questions. And as always, if you would like to reach out to me for a personal consultation, you can do that by going to my website, lilylegal.com, or by calling my office at 508-443-1788. And that is it for today. Thank you so much for your time. And remember, if you like this video, please hit the like button. If you know someone who needs to hear this, share this video with them. And if you are watching in a place where you can subscribe, go ahead and hit the subscribe button so you don't miss any of my uploads. And once again, I am Lilian Chukura. I am the owner of Lily Legal, where we do immigration law and we do it well. Thank you again. Bye.